we've already got 65 people logged on, and we've had a massive turnout for this one. So I'm thinking it's the time of year where everybody's thinking about handling and managing sick employees. It's one that's keeping me busy, I have to say. So on a day-to-day basis, I'm sort of giving advice to my clients, mainly companies, about managing sickness absences. And we thought, because we'd had some good feedback from people in one of the last seminars, that it would be good to just run a very brief webinar on sickness absence and where we're all at with it, because I think this is quite a common problem. Okay, so I'm just going to test this out. Here we are. So I've got two types of sickness absence that seem to cause all the problems in the workplace. We've got short and frequent absences, and what they tend to call those are intermittent absences, which are disruptful on many levels. And a great example I've had of this is actually when I was teaching. I used to teach at the College of Law, and on a Tuesday in one of the lectures, hardly anybody was in this particular lecture. And we had an issue with, why, what's going on. And in the end, it turned out that there was a particular thing that happened the night before. Nearly everybody went, and they didn't turn up the following day. And at the time, I didn't think anything else of it. But I have now experienced this with some of my employer clients, where if they're keeping a good log of intermittent absences, they're identifying patterns. And that's the key, I think, with short and frequent absences, is to start to identify a pattern, to have a system in place. There's lots of systems out there to monitor. There's lots of HR systems. But once you get a pattern, you might see, I don't know, sometimes at a firm I used to work at, we had an issue with Tuesdays after the bank holiday Monday. And there was one person who repeatedly always took the Tuesday off. And that became a pattern, and then we dealt with that using a process. There are also, sometimes there are people who are always away on a training day, and it's not necessarily even to identify people to be disciplining them, but to identify why and the reasons for the absences, to stop them, because sometimes short and intermittent absences are more disruptive than the longer term absences. You can't plan so well for them. The second issue then is the long-term absences and all the implications that come with that. I mean, obviously there's cost implications depending on what you pay, but also I think there's a fear amongst companies about managing people who are away from the workplace on long-term absences. And I don't think there should be, because it's all about communication. I've run quite a few tribunal cases for respondents and for claimants, because I've acted and still do for both. And actually, I think the key to nearly every single claim that's ended up in the tribunal is a lack of communication or an inappropriate style of communication in relation to the absence from one or both parties, normally both. So those are the two issues we're going to briefly look at today. Okay, so when we're looking at managing absences then, I've got various things to think about, but what we really need to look at is, have you got a decent sickness absence policy? What's your policy? Where are you setting your standards? Again, I can only look at it from a sort of litigious perspective. I'm not a qualified HR professional, but from my perspective, when things get to me, if there's a serious dispute and or a risk to the business litigation-wise, the first question I always ask is, where's your policy? What does your policy say? If you've not got a policy, you need to be getting one. I've got loads of policies for lots of different businesses, and tailor it to suit your business needs. So identify where you're going with your sickness absence policy, what are your standards, and set them out clearly. I've said at the bottom of that slide, but I'll say it now. Once you've done that, act consistently. I've had one particular client who's turned around their sickness absence issues just by implementing a decent policy and then uniformly applying it. I mean, obviously there are some exceptions to that, but being consistent so that everybody knows what will happen when they're sick. Everybody is treated in the same way, give or take any disability issues, which I'll come on to. And it's fair. And once they started treating people fairly and consistently, and there was also a fear that the absences would be managed and a knowledge that they were being monitored, it did turn around what was a potentially horrendous issue for them. And in that case, I had an allegation of disability discrimination, because the line managers have been given too much leeway on discretion, basically, and they were treating people differently. It's really helpful to line managers as well if they're all operating from one standpoint rather than, coming at it from different angles and applying their own discretion, because everybody's discretion would be applied differently. Okay, so get your sickness absence policy in place. Then monitor your absences. I touched on this earlier, but keep in touch on longer term absences. Keep in touch. Show that you've kept in touch. Email or by letter, even the odd phone call, but make sure you've something in writing. Keep in touch. Keep the communication going. Show that you want to get people back to work if it's a longer term issue. And if it's a shorter term issue, start doing return to work interviews more often so that you've got a fuller picture of why the person was away, what was the issue, and so you can build up some kind of, I suppose, a backstory as to when and why the absences are occurring. Writing to occupational health, I'll come on to that in a minute. That's a great one. So along with your return to work interviews, if there are any issues or if it's a longer term absence, you might want to go to occupational health and get medical evidence. I'll come on to that. That's my next slide. You've preempted me, Carol. So the other thing is, if you do have a policy, normally if you've got sickness absence policies, they will then set out a 3-stage meeting process normally to handle people who have basically an ongoing issue. And those policies normally include 3 meetings, and we normally give employees a right to be accompanied, particularly if it's going to result in any kind of warning. Some companies do give warnings, a number of various, all sorts of warnings. They have more than 3 meetings. Some just stick to a 3-meeting process. And then on the 3rd meeting, that might be a dismissal if somebody's not fit to work. Keep minutes of all your meetings. Again, from my perspective, when I end up in a tribunal or in a dispute, or I'm trying to come to an agreement with somebody to leave a company or an organisation, or I'm acting for an employee, we need to see the whole picture. Minutes of meetings are great because it gives us a full picture of what's gone on, and if you do end up in a tribunal worst case scenario, at least the tribunal can see what's been happening and how you've been dealing with matters. And I've got a comment here just on contact saying we found that asking people to contact their manager together with a return to work interview reduce short-term absences considerably. I agree with that. I think that's right because they're being properly managed, although I do appreciate it's hard if you've got a lot of people off. The other thing to think about is what are your terms if you've got a policy regarding pay. I have lots and lots of companies who still, who I act for now and have been with me a long time, who 10 years ago decided it would be a great idea to give a good chunk of full pay for sickness absences. And that's great, and I really do, in some circumstances it's wonderful and people can really have time off and not worry about whether they're losing out on pay. But it can be a double-edged sword, and I have other companies who are finding that there are certain individuals who maybe if they weren't receiving full pay would have been fit to return sooner, and don't come back until the sick pay has expired. I've now, going forward, what I've noticed in the last 2 or 3 years is that many companies are offering sort of a statutory sick pay, basically. The other thing about payment is, one of my key bugbears is when somebody is being disciplined for something that's not related to sickness absence. So maybe there's a disciplinary process for one issue, but they go off sick immediately and they say, well, I'm going to be off sick now for 3 months and you've got to pay me full pay. That is a killer. Some of my clients now have a sentence in their sickness absence policies in relation to sick pay that says if you're in the middle of a disciplinary issue, or if that's commenced and then you go off on the sick, it's SSP only to discourage that. I don't know what I think about that, rights or wrongs, but it certainly saves some people money. Oh, good. We've got a good bit of chat going on here. Yeah, good. So everybody can see the chat box, can't they? So sorry, I won't read it all now, but do read the chat box because it's really interesting. And yes, the other way to deal with minutes and recording meeting is to put in an outcome letter and send it directly to the employee. I'm happy, either way with that, as long as there's a full policy. Company sick pay at the company's discretion. That's a funny one, because again, it is open to challenge, isn't it? I suppose the exercise of a discretion is always open to challenge, isn't it? And an allegation that there is perhaps the discretion has been exercised in one person's favour rather than another person's favour for different reasons. So, you could say, I'm giving it to, and a good example, let me think. A good example would be, I'm giving full pay to Marie Walsh because she has broken her arm and I know that she'll be fit for work in 3 weeks. So on that basis, I'll pay her 3 weeks because that will be short-lived. This is a real example that I've had, obviously not with myself. And then somebody else saying, well, hang on, somebody else has got something a bit more serious, and I don't really want to pay them full sick pay because I've no idea when they're coming back, so we'll just put SSP. Now, if that more serious issue is a disability, for example, then you could be open to challenge there. Why have you exercised it differently? What is the reason? Well, in that case, the reason was that, the person could potentially be disabled enough for a long time. Is that potentially discriminatory? I think so. So you've just got to be a bit careful about discretion, and although it does come in handy, but, yes, I think it could be disability discrimination. Good. Right, okay. So the next slide is medical evidence. So there you go. In relation to medical evidence, as part of any process for sickness absence management, I would say, first of all, beware of that case recently, I can't remember what it was called now, that said, don't just rely on an occupational health report to decide whether somebody's a disabled person or not. I think it was Glossop, I might be wrong. So beware of that. Use your own common sense was basically the outcome of that case. Make your own investigations as well. Look for evidence of incapacity, though. There's nothing wrong with that. Again, I've got a suite of letters which I send out to my clients, which allows them to get access to medical records, get the relevant consent. And some people either go for a GP report, and this will be a contentious point as well, really. Do you go for a GP report? A lot of my clients say, well, I don't now, because the GP just tells me what the employee tells me, or tells them to tell me, and I don't get anything out of it, and it doesn't help me at all. So on that basis then, other clients have said, right, can you recommend a good occupational health service? And actually, I think it might be worthwhile you all sort of swapping tips on if you use external occupational health providers, because they are actually in demand. And when you put a note out there saying, does anybody know anybody good, I don't think there are as many people as you think who are independent occupational health specialists. I might be wrong. Maybe we could swap details of good occupational health companies sort of up and down the country. It might help you all out. The other obvious service at the moment is Fit for Work. Obviously with the occupational health, I mean if you don't have somebody in-house, there is this Fit for Work service, and I don't know, I've used it once, 2 or 3 of my clients have tried using it, and it seems to be okay. The feedback I've had was that it was a bit slow. It was slower than they'd anticipated, but I have to say that when they were using it, it was as it was new and it was just coming into play, and I haven't had any really negative feedback, but I might try and get some actually and feed that back to you next time. I don't know. Mixed reviews. I think the feedback I had was that it wasn't brilliant, but it was in its infancy, so I think it's quite good. A local council's occupational health team, that's fine. I know that up here some people use York Hospital. They've got a good occupational health service there, which seems to be quite good. Anyway, Fit for Work, I'd be great to receive your feedback on that, because, like I say, I used it at the very beginning, and just one of my clients said it was a bit slow, but I've not heard anything negative else about it. Now, the reason we're doing that is that what we want to demonstrate to the tribunal, or to, again, I sound negative, I always deal in sort of worst case scenarios. If we're in a dispute, we want to show that we are looking to rehabilitate people into work, not just say, you've been sick, you're dismissed, but rather to say, look, what can we do to help you in work? What's the reason for your absence? How can we accommodate you? And again, if you've got good advisors, they should be helping you to prepare a letter to the occupational health people to say, with a list of questions, to say, is this person a disabled person, and also to deal specifically with the role, and to, try to establish good accommodations to limit absence and to help people to stay with the company for long term. I've got one question here about medical evidence, about intermittent short-term absences. Can you ask for doctor's notes, and how does it tie in with the fact that fit notes aren't needed for the first week? I mean, that's a really good one. What I tend to do there is if somebody is repeatedly off work, one day, and here and there, and on the return to work interviews, it's always the same issue, or, it might say it's a stomach complaint. It wouldn't be inappropriate to ask for a medical report to deal with, look, the last 3 times you've been away, you said it's your stomach, we want to look into this further, obviously causing absences. You can ask for them to provide a GP note every time, but it's not practicable. And also, what I've found, this is just my experience with my clients, is that the GP will say, that's fine, but you've got to pay. That's the next thing down. We've asked for doctor's reports for short-term absences and foot the bill, but for repeat offenders. So you could do that. I haven't had much luck with intermittent short-term, but definitely if somebody's been off 2 or 3 times and it's related, or it could be related, if you have a good return to work meeting, it might be that there is an underlying health issue, and I'd definitely go for it, just to show that, if anything else, that you've done as much as you can to accommodate the person. I like the idea of suspending the right to self-certify. I don't know, I've not come across that before. I don't know if you can remove the right to 5 days if you write to them about self-certification. I think you probably can. I don't know is the answer. I could look into that. I'll look into that. Okay, so when we're looking at rehabilitating people into work, we're looking at things like a phased return, and somebody did say in the chat earlier, the phased return sometimes means that they return on reduced hours, but then they only get paid for those hours. So sometimes a phased return doesn't fit nicely with full pay company sick pay. Although I have to say, I have dealt with people who are so keen to return to work that it doesn't matter to them. Not many, but genuinely sick people who do want to work don't tend to have an issue with it. And actually, if you were minded to and somebody was pretty decent about it, you might choose to enhance that. I don't know, it depends on the nature of your company. There might also be alterations in duties, varied start and finish times. There's lots of other equipment and software out there as well for lots of different types of illness. It's a big... There's lots of accommodations that we can make. For example, one of the areas is dyslexia. So many different things you can get now to assist people who have dyslexia in the workplace. Something as straightforward as changing the colour of the screen, or can just improve people's attendance and also their productivity no end. So always make sure that you've had a good investigation into what accommodations you can make. I've only put a few there, but obviously there are loads. Let's have a look. So in the chat now, we've got phased return for longer-term sick, coupled this with holidays. That's a good idea. Yes, I've done that as well, because the holidays are obviously still accruing during periods of sick pay, and some people do want to receive full pay, so that's a great idea. Also, payment for return to work depends on what hours and where they are in terms of their sick pay. Yes, okay, fair enough. Phased back on full time, as long as average of 50%. Okay, yep, fair enough. And then we've got SSP with occupational, as soon as they return to work. Okay, I like that as well. Okay, so I'll come back to them. So there's loads of different good ideas in the chat box there. This is all good stuff. Well done, everyone. This is fantastic. I really like it when it's interactive. I think we're up to 90 people on this nearly now. So, yeah, hopefully, if you've just logged on, you can see back up the chat box and see what you've missed. Okay, one of the main issues in relation to managing sickness absence, and I did touch on this very briefly earlier, is disability discrimination. In every case that I've ever run or defended in relation to disability, the first thing that the tribunals look at is the person a disabled person for the definition, under the definition of the Disability and the Equality Act. And what you need to be looking at there is, do they have a physical or mental impairment? Does it have substantial adverse effects on normal day-to-day activities? And then, is it long-term? And long-term means likely to last or has lasted 12 months or more. So somebody doesn't have to have suffered with an ailment for 12 months. If it's likely to last 12 months, then you might have an issue. So if you do conduct return to work meetings, you've spotted any patterns, or you're long-term sick, and you've got medical evidence which suggests somebody may be disabled, or they're on the cusp, or they're not sure, think about it in those terms. Think to yourself, well, if I was asked, is there a physical or mental impairment, what's the answer? Do yourself a little checklist, that's what I do. What are the effects? And you can get that if you're doing good return to work interviews, and if you're getting good medical evidence, you can see what the effects are and whether they're substantial. And also whether they are substantial on normal day-to-day activities like, getting up, getting dressed, going to the shops. I don't mean somebody's no longer a concert pianist, but is it affecting them? And remember, the effect of medication is not taken into account when we're assessing disability. And I have had clients in the past who have said, well, there's nothing wrong with him or her. They seem to be coping quite well. And you think, yeah, but they are on 6 different types of medication. And when we're looking at disability, it's whether or not without the medication there would be a disability, which I think some people tend to sort of skip over. If you think there is a disability, you have a legal obligation as an employer throughout any kind of process and prior to any dismissal to consider reasonable adjustments for the employee. And again, this ties back into your medical evidence. If you're doing good letters to occupational health, GP, in-house, then what you should be getting is a full synopsis of what's going on with the individual and also what's causing them a problem and what reasonable adjustments you can make to accommodate them. And the key here is reasonable. What's reasonable? Do you have to take on 2 people to do one person's job? That probably wouldn't be reasonable. But could you change hours? Maybe. Could you give, a later start on particular days if somebody has an arthritic condition or something that, or a stomach complaint, which means they can't get into the office until later in the day for whatever reason? Yes, you should be considering that. It's about really understanding the illness. And again, it goes back to your medical evidence and your return to work and communication. I've seen some good reasonable adjustment claims go through where there's just been a complete lack of understanding of a person's particular complaint and what might have been done to assist them. Instead, the employer has seen it as a problem, and they've resolved the problem by seeking to dismiss without doing anything else first. So I'm sure none of you do anything like that, but, think about reasonable adjustments. Failure to make reasonable adjustments is in itself a claim that somebody can bring. Remember that for a discrimination claim, an employee does not have to leave. So they don't have to resign. They can start ACAS early conciliation at any time, within 3 months of when they say an act of discrimination occurred, for example, a failure to make an adjustment to accommodate them in the workplace. They can remain employed by the company, and then they can bring a claim. Okay? It's unlimited damages, and there's an injury to feelings award. So it's in everybody's interest. Employees don't want to bring claims like this, and in fact, just recently, because of the fees regime, etc., my experience is that people are not progressing it to a claim. But they can, and if forced to, they will, and they are able to do so. If they then suffer further detriments after they've raised issues or raised a complaint about discrimination, they can also bring a claim for victimisation. And it would become a company's worst nightmare. I've seen it spiral out of control. So communication back onto adjustments, etc., to me is the key. If you can't help anybody, you've made all your inquiries, there's a genuine problem or there's issues that cannot be resolved, then it is possible to dismiss an employee. I say this as a last resort on the basis of capability. So capability is a fair reason to dismiss employees under Section 98(2) of the Employment Rights Act 1996. It's one of the 5 fair reasons. Misconduct is another reason, and I say that now because sometimes I think there's a difference between they can't do the job, which to me is capability, and they won't do the job, or there's an element of intention in there not to turn up, or misbehaviour, should I say. So think about it carefully. What's your reason? If it's that somebody's deliberately just not turning up for work and there's really nothing wrong with them and they're just, they like having Mondays off, for example, or they're always late on a Thursday or for whatever reason, no underlying health issues, go with misconduct. If it's capability genuinely, then go with capability, but pick your right reason if you are seeking to dismiss. If you do want to choose the reason of capability, if that's the real reason, then follow a fair process. I've referred to it before, but follow your policy. Show that you've followed your policy. I love defending cases where the employer can say, well, this happened, here's my policy, here's what I did, here are my minutes, here are the meeting notes, here's my letters to the employee. Brilliant. And I really like that. Follow the process. And the process I've said generally, I mean, obviously it will depend company to company, but generally we have 2 meetings prior to a final meeting at which the person may be dismissed. And during those meetings we set out, all of everything that I've just said. So adjustments, what are the main issues, how we can help. I think capability meetings should be a 2-way street, and they should not really be confrontational unless absolutely necessary. It should be all about helping and assisting the employee to stay. Generally a right to be accompanied, particularly at the last meeting. Big policies normally do if you've got a proper warning process, and there's a right to appeal normally at the end of each stage and or at the dismissal stage, obviously, as you would expect. And I've said employment tribunal claims, well, they run from the date of the last act of discrimination, 3 months, or from the date of dismissal. It's actually 3 months less 1 day. But remember, the ACAS conciliation stops the clock, so your employees can get extra time. Margaret's mentioning here that some people have legal expenses insurance to bring claims. They do. This is very, very common at the moment. Many employees have family legal expenses insurance, which are included as part of house and contents policies, and provide them with thousands of pounds worth of legal cover. What I would say to you about that is that I wouldn't use it as a scare tactic. I don't to my clients, because still an employee would still have to have 51% chance or more of pursuing a reasonable claim for it to be funded. So it's not a sort of, I've got a claim, you're funding it job. It is properly assessed, and they are only allowed to proceed if it's got prospects and if it's legitimate. So I certainly won't be scaring people into, everybody might bring a claim, and it's fine. Oh, very good, thanks. Right, thanks, Kerry. So we've got, section 982. Okay, so I've got something else on the chat here. We've got employees who receive formal warnings and do not have an absence of 6 months while this is live, then repeat the pattern of behaviour and start the process again from the beginning. Can we switch this to conduct? It depends in each case. If you've got a pattern, you might want to have a look at your process and change it. I mean, if that's what's happening, you might want to keep your warnings live for longer. Try and change your policy. If it is just a policy, I would certainly do that. And yes, and we've got some good feedback there about having discretion in the policy. So I would probably look at the policy again. It sounds to me like your policy's not working for you there. You might want to bring it up to date. Now you've got a pattern and you can tailor it to the needs of the business, certainly. And then we've got a backsliding period there for 12 months as well. That's really interesting. I like that. Some good tips on policies here. Remember, if you've got a sickness absence policy, you can change it as long as it's not a contractual change. If you've got contractual sick pay, obviously be careful, but you can make changes to your policies, and you can make contractual changes actually in the longer term, following the correct processes if there is a massive issue with your sickness absence issue. Right. Okay. So we've got there at the end of it. I think we've reached the end. I said I'd do it for about half an hour. I'm sorry I've gone through that really quickly, everyone, but I particularly like the feedback.